A Supreme Court story is blowing up online, and a lot of gun owners are hearing the wrong message. If you trust that message at your next traffic stop, you could make a smart move feel like a criminal mistake. Pause. Quick question before we continue. Are you subscribed? Because what I'm about to reveal could keep you from trusting a fake legal update at the worst possible moment. Hit that button now, because laws do not care whether bad information came from a slick video. Here's what just happened. A bunch of viral videos started claiming the Supreme Court made a big 9-0 ruling that changed guns in cars forever. The pitch sounds simple. Too simple. It usually goes something like this. You can carry more freely now. Police cannot mess with you the same way. And your privacy on the road just got a huge boost overnight. That sounds exciting. It also leaves out the most important part. There is no recent 9-0 Supreme Court decision that suddenly gave unlimited gun rights in your vehicle or made traffic stop rules disappear. And that matters because bad legal advice spreads fast. It feels good. It sounds strong. It gives people false confidence. Then real life shows up. Imagine you're driving home after a late shift. You have a handgun in the car. Maybe you think your permit covers you everywhere. Maybe you think a viral headline means the officer cannot ask certain questions. Maybe you think a rental car changes everything in your favor. If you act on the wrong idea, that roadside moment can go bad fast. Here's what most people get wrong. They think one giant case controls everything. But the truth is, your rights on the road come from different cases, different facts, and different state laws. Gun rights is one lane. Search and seizure law is another lane. Traffic stop procedure is another lane. And if you mix them up, you can end up very confident and very wrong at the same time. So let me break this down for you in the clearest way possible. First, the big public carry case most people talk about is not a 9-0 case. It is Bruen. That was a 6-3 decision. And what Bruen said was important. The court said ordinary law-abiding citizens have a right to carry a handgun in public for self-defense. That was a huge Second Amendment ruling. No question. But here's the crazy part. A lot of people heard right to carry in public and turned that into, I can carry however I want, wherever I want, and every state has to like it. That is not what Bruen means. Bruen did not erase every permit rule. It did not bless every carry method. It did not wipe out sensitive place restrictions. And it definitely did not mean every officer in every state has to ignore local gun laws during a traffic stop. Think about a simple example. Say you legally carry in one state and then drive into another state with different rules on permits, magazine limits, storage, or vehicle carry. Most people think their good intentions matter. But the truth is, the local law matters more than your intentions. If that state does not honor your permit, or if it has strict transport rules, you may be dealing with a whole different legal world the second you cross that line. That is why this topic is so dangerous. The viral version makes you feel safer. The real version says slow down and check the law before your tires ever hit the highway. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that can help you protect your rights without making a traffic stop worse. Subscribe so you don't miss it. Now, this is where it gets interesting. There actually is a unanimous Supreme Court case about privacy in a car, but it is not the sweeping gun rights miracle some people online are selling. The case is Byrd v. United States. And this one matters a lot if you drive a rental car. Here's the simple version. In Byrd, the Supreme Court said that if you have permission from the renter to drive the rental car, you can still have a reasonable expectation of privacy in that car, even if your name is not listed on the rental agreement. That was a 9-0 decision. And yes, that is a big deal. Why? Because before that, some people argued that if your name was not on the rental contract, you had no privacy claim at all. The court rejected that broad idea. In plain English, the justices said, you do not lose all Fourth Amendment protection just because the rental company paperwork is imperfect. But wait, there's something even more important. Byrd did not say police can never search a rental car. It did not say traffic stops are now harmless. It did not say an officer needs your permission in every situation. It did not create a special gun owner shield. It simply said some drivers in lawful possession of a rental car can still claim privacy rights. That word lawful is huge. Here's a hypothetical example to explain this. Let's say your girlfriend rents a car. She tells you to drive it. You are using it with her permission. Under Byrd, you may still have privacy rights in that car. Now change one fact. The car is stolen, or you got it through fraud, or you're driving it without real permission. Different story. Privacy claim gets much weaker, maybe gone. And even when privacy rights exist, roadside reality still matters. If an officer stops you for a real traffic violation, that stop can still happen. If there is probable cause, that changes things. If you consent to a search, that changes things. If there is evidence in plain view, that changes things. So Byrd is important, but it is not magic. Now let me connect that to guns, because this is the part nobody's talking about clearly. If you have a firearm in a borrowed or rented car, you have 2 legal questions at once. Question 1, is your possession of that firearm legal under the laws of that place? Question 2, what privacy rights do you have in that vehicle if police want to search it? Those are not the same question. A person can be legal on one and weak on the other, or strong on one and in trouble on the other. Now, quick legal note, this is educational information, not legal advice. Always consult an attorney for your specific situation. And there is one more case you need to know, because this is where online headlines start blending cases together. The case is Caniglia versus Strom. That was another 9-0 ruling. It involved firearms and the Fourth Amendment, but it was about the home, not the open road. In Caniglia, police took guns from a home after a welfare check. The lower court had allowed that by stretching a car-related idea called community caretaking into the house. The Supreme Court said no. The justices made it clear that what is allowed with vehicles is different from what is allowed with homes. In simple terms, police do not get a free pass to enter your house and seize firearms without a warrant, consent, or a real emergency just because they say they are acting like caretakers. That ruling was strong. It protected the home. But don't make the mistake of dragging that rule back onto the highway and saying, see, now my car gets the same protection. It does not. Cars and homes are treated differently under the Fourth Amendment. The difference has been in the law for a long time. So when a headline says one unanimous ruling changed both gun rights and privacy on the road, what it usually does is mash different cases together and hope you never notice. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the people who want real gun law updates, not clickbait. Click subscribe, because one bad legal myth can cost way more than 1 second of your time. Now let me explain why this matters even more in 2026. Some gun owners heard Bruen and thought the courts were about to strike down every gun restriction in sight. Then Rahimi came along. That case was not 9-0. It was 8-1. And the Supreme Court said that when a person has been found by a court to pose a credible threat to someone's physical safety, that person can be temporarily disarmed. That means the court is still recognizing limits. This is the part that shocked me when I first saw how people online were talking about it. They were acting like the Supreme Court flipped a switch and every gun law got weaker overnight. But the truth is more complicated. Yes, the court has strengthened parts of the Second Amendment. Yes, it has protected some privacy rights. But no, it has not created a nationwide free-for-all for guns and cars. So what should you take from all this? First thing, stop trusting headlines that make the law sound simple. Real law is almost never simple. If somebody says, the court just made this legal everywhere, that is your first warning sign. Second, know the law of the state you're in, not just the state you came from. Carry laws change at the border. Storage laws can change. Disclosure rules can change. Magazine and ammunition rules can change. Sensitive place rules can change. Most people think, I'm a good guy, so I'm fine. The law does not grade on good intentions. Third, understand the difference between gun rights and search rights. A lawful firearm does not stop an officer from making a lawful stop. And a privacy claim in a car does not automatically make the firearm legal. Those are separate issues. Fourth, think about the real-world traffic stop. Imagine blue lights in your mirror. Your heart jumps. Your hands get sweaty. This is not the time to test a theory you heard from some guy online. Keep your hands visible. Follow commands. Do not make sudden moves toward the glove box or center console. If your state requires you to tell the officer about the firearm, follow that law. If it does not, that does not mean you should freestyle the moment. Stay calm. Ask how the officer wants to proceed. Fifth, do not confuse the shoulder of the road with a courtroom. If you believe a search is unlawful, this is usually not the place to fight it out with speeches and attitude. You handle that later, through counsel, in court. A lot of people lose good legal arguments because they turn a simple stop into a bad scene. And sixth, be extra careful with borrowed cars, rental cars, and cars shared with family or friends. Permission matters, possession matters, paperwork matters, facts matter. One tiny detail can change the whole case. Here's what most people get wrong at the end of all this. They want one sentence, one magic rule, one answer that works in every state, every car, and every traffic stop. But the truth is, you need a checklist, not a slogan. Is the gun legal here? Is my permit recognized here? How must the gun be stored here? Am I required to disclose? Am I driving my own car, a borrowed car, or a rental? Do I actually know what the law says? Or am I repeating a headline? That is how you stay safe. That is how you stay smart. And that is how you avoid becoming the test case nobody wants to be. Laws change fast, and bad advice spreads even faster. Subscribe now, because the next video breaks down the exact traffic stop mistakes that can turn a legal carry into a criminal charge before you even realize what happened. So here's the bottom line. No, the Supreme Court did not hand down one brand new 9-0 ruling that suddenly changed every gun right and every privacy rule on the road. The real picture is this. Bruen expanded public carry rights. Byrd protected some privacy rights in rental cars. Caniglia protected the home from a stretched car search theory. And Rahimi reminded everyone that gun rights still have limits. If this video cleared up the noise for you, subscribe and stay with this channel. I do the hard research so you do not get trapped by bad legal myths at the worst possible time. And one last simple disclaimer: laws are different from state to state, and every case depends on facts. So talk to a qualified attorney about your own situation before you rely on anything you heard online.